Okay, we are now in week 6 of your Social Security, Workers' Comp. I think it's Workers' Comp, Social Security, and Bankruptcy class. We're continuing with Bankruptcy. We are now going to go into the Chapter 7 consumer case. So, what does that mean? Remember, there are different chapters of the Bankruptcy Code. Different chapters deal with different kinds of debtors. And different kinds of bankruptcy relief. So, Chapter 7 of the Bankruptcy Code is for consumers, and it is for complete liquidation. Now, businesses can also file for a liquidation, but we're going to go through consumers because that's the bulk of what you would be dealing with in a small bankruptcy practice. Okay? So this chapter goes through what the petition looks like, all the component parts. Each part of a petition is called a schedule. I don't know why, it's just called a schedule. And by the way, we call this a petition because it is non-adversarial, at least at the outset. There can be some adversarial proceedings within the case itself, where creditors are now contesting certain things that you might have in your petition. But a petition is when individuals go to the court and they say, we don't want to sue anybody, we don't want to have a problem here, we're asking the court for relief. And so that's why we call this a petition. And again, every section of a petition, all the supporting documentation, is called a schedule. And different schedules are for different kinds of debts or different kinds of just disclosures that you're making to the court. Okay? Now we're going to deal with a voluntary petition. There can be involuntary, and we'll talk about that. But a voluntary petition for bankruptcy is where you knowingly, without any duress, say, this is what I want to do. So a voluntary position. Oh, and I want to start by saying I am going to ask you to go to uscourts.gov forms, bankruptcy forms. That's where you will find the bankruptcy petition. All of the schedules. You can't fill them out. They're just the forms. But you can then compare what's in your book to what's online so that you can get a better idea of what this is all about. Okay? Now, these types of petitions can either be filed by an individual or by a married couple jointly. Why do we do that? Well, even if I'm married, I might have debts that are just mine. So maybe my spouse wants to not file for bankruptcy. I can still file individually. If I'm not married, I can file individually. And if I'm married, I can file jointly. Not if I'm living together. You must be legally married to file a joint petition. Now, what if I'm going through a divorce and I file for bankruptcy and my spouse files for bankruptcy and we're going through a divorce? The court can consolidate those two cases because in the interest of judicial economy, we're just going to put the whole thing together so that we don't have any mess, especially when we get to domestic relations court for the divorce. This happens a lot. Where one spouse is ordered to pay certain bills and the spouse says, forget it, I'm not paying these bills, and doesn't tell their current spouse. They're still in a divorce, they're still married. So let's say husband says, forget it, I'm not paying all these bills, files for bankruptcy, doesn't tell wife. Then all of the bill collectors start calling wife. And wife is like, what am I supposed to do here? She's going to be forced into filing for bankruptcy. Now you've got two bankruptcies for one household. So the court will jointly consolidate those. Okay? Where do we file a petition? Well, we file, this is called venue. You go where basically you live. You're really not allowed to file a bankruptcy in a jurisdiction where you don't reside. There's a residency requirement. Why is that? Well, a bankruptcy petition puts creditors on notice. Remember that this bankruptcy process is to give relief to the debtor, but to protect the creditor. And if I file my bankruptcy petition in California and I live in Ohio, my Ohio creditors might not even know that I filed for bankruptcy. Now, if I file, excuse me, in Cleveland instead of filing in Youngstown, is it that much of a big a deal? It's still a deal. So we want to have it where you are a resident. Okay, there are several signatures that are required on a bankruptcy petition. You have to certify that, in fact, you are voluntarily doing this and that what you have put in the petition is true to the best of your knowledge. There must be a certification by an attorney, and the attorney certification, if you use an attorney, the attorney certification is that the filing is not being done for any improper purpose, like just to frustrate a creditor, that the factual allegations or denial of anything will have evidentiary support. So if we say we don't owe something or we do owe something, we've got the bills. We've got the documentation to support whatever is in that petition. And that all legal contentions are warranted by existing law or a non-frivolous argument for what the law should be. So basically, a lawyer has to say, I'm not filing junk. I'm not trying to skirt a creditor. I'm just trying to protect my client's interests by filing for bankruptcy. Okay? Remember I told you that what you need to do 180 days before you file for bankruptcy is go to a certified debt relief agency? Well, there needs to be verification of that filed with your petition for bankruptcy for Chapter 7. And if you use someone who's not an attorney to help you file your bankruptcy petition, that person needs to sign off. Now, I will tell you, not very many people use bankruptcy petition preparers who are non-attorneys who will help you fill out your paperwork. Why is that? Well, because under the law, you can be held responsible in damages if you are acting like a lawyer but you're not a lawyer. And you don't want to do that. And by the way, as a paralegal, you don't want to do that. You don't want to give legal advice to anybody and pretend that you're an attorney, because someone can come and get you. Okay? So if by chance, the off chance that you use a bankruptcy petition preparer, you want to have that person sign off on the petition. Okay? There is a filing fee that you have to pay when you electronically file your petition for bankruptcy. Well, how in the heck are you going to pay a filing fee if you are filing it electronically? My credit card. Attorneys will have lines of credit cards that are just for filing fees. And what will happen is that card will be debited, but at the same time, the client has to pay the attorney. You can also get 120 days to pay the filing fee. After all, bankruptcy court recognizes that you're in bankruptcy court because you're having financial trouble, right? And so you can put in a petition saying, I will pay this within 120 days. Your case won't ever be discharged or completed if you don't pay that filing fee, and sometimes they'll even kick you out. Sometimes they'll even dismiss your case if you're really not paying anything. Okay? But there is a schedule. Generally, it's $50 every 2 weeks or a small amount every 2 weeks. Attorneys generally will not file a petition for bankruptcy, especially a Chapter 7 petition for bankruptcy, unless you have deposited with them all of the filing fee. Why is that? Well, not just the filing fee, but also the attorney fees. Why is that? You're probably not going to pay them. There's a reason why you're in bankruptcy court. So attorneys want to make sure that their fees are paid up front and that you at least pay the first part of the filing fee if you're paying it in installments before the petition gets filed. Oh, that's really stinky. That's really horrible. I'm going to tell you. I would have people who would come in with tons of debt, tons, and would say, there's just no way I can pay your attorney's fees. And I would say, I'm really sorry, I can't do this then. And miraculously, the next day they would come in with the money. They would either borrow it, or it would be hidden under the mattress. Whatever it was, they came up with the filing fee and with the fees. It's just the way it is. People will prioritize the way that they prioritize. So understand that those are like the real life logistics of filing fees and attorney's fees. Okay? Now, there are involuntary petitions. What the heck is that? Overwhelmingly, these cases are voluntary. But involuntary means that the creditors, your creditors, especially your secured creditors, have gotten together and said, you know what, you've filed for a reorganization under Chapter 11 or Chapter 13 of the Bankruptcy Code. You're not going to be able to do anything. We're not going to be able to agree on a plan of reorganization. We are now putting you involuntarily into a liquidation, a Chapter 7. Okay? It is not easy to do that, and it is kind of the last resort. But it is a way for creditors, again, to protect their interests. If you are in a position where you're really trying hard to put together a schedule so that you can repay your creditors, and it just doesn't look like that's going to happen, that there's just not enough income there to get you to the finish line, all of the secured creditors can band together and say, we just want to take possession of our collateral. We're entitled to that. And we're never going to get to the finish line with a plan of reorganization. Lots of times the courts will find that persuasive. And again, it's not an easy thing. There are adversarial hearings that take place all along the way. Okay? So let's go on to the schedules. The schedules are, let's see, again, the schedules are all the lists of stuff that you have in your bankruptcy estate. Okay? The list of creditors is the first thing that you need to put together when you're putting together a bankruptcy petition. Again, if you're using the software program, the software will lift all of those creditors out and you won't have to do anything. This is called a matrix. Not like the movie. It's a matrix of your creditors. It is what the court will use to send notices to your creditors that they need to file notices, or that there's a hearing coming up, or that there's a deadline coming up. Okay? So it's your responsibility as the debtor to inform the bankruptcy court not only the list of your creditors, but where they are to be contacted, their mailing addresses. Okay? So this gets attached to every petition, any kind of petition for bankruptcy that you have as your matrix of creditors. Lots of times, again, your software program will pull all of that out for you. They're generally done in alphabetical order. And this, again, is what the court will rely upon. They will then upload that matrix into their system, and everything will go out to them that way. If you have email addresses, that helps too. Lots of times you don't, but if you have email addresses for them, that helps too. Okay? Okay, Then we get to the schedules, Schedule A and B. This is a description and location of all your real and personal property. Now, it's not just what you have, but it's also what you owe on them and how much equity you have in them. You need to list everything. Real property, who owns the mortgage if there is a mortgage, if you own it outright, and all of your personal property. Now there's a list that you go down on Schedule B for all of your personal property, and it lists things like firearms, furniture, personal belongings, vehicles, boats, bank accounts, all of those items, and you have to say whether or not you have them and where they are and what the value is. Now, how do you know what the value is? Well, remember we talked about exemptions. Every state has an exemption that you are entitled to whenever you file for bankruptcy. The federal government also has a table of exemptions. What you do is you look at the Ohio exemptions and the federal exemptions, and you look to see which one's higher. Lots of times the state exemptions are higher than the federal exemptions, but whichever it is, it is. And when you put a value down for your personal property, you make it as close to that exemption amount as possible. So if I have an exemption in Ohio of $2,500 for furniture that I own, on my Schedule B, where it asks for the value of my furniture, I'm going to put $2,500. Why? Because I know that that amount is exempt, and no creditor is going to be able to say, sell that furniture. Because if the furniture sold, the value of it comes to me. The first $2,500 of the exemption comes to me. Okay? Same thing with vehicles. Same thing with pretty much everything. You look at the tables of exemptions. You see which one has the higher dollar amount. You list that dollar amount on Schedule B. And then on Schedule C, you are going to list all of the property that is exempt. Okay? That means you're going to go through and list every exemption that you believe you're entitled to. So in Ohio, there is an exemption for personal property, for personal real property, for your home. Okay? The homestead exemption. So you're going to put that dollar amount and the statute that gives you that exemption on Schedule C. There's an exemption under Ohio law and federal law for personal belongings. So you're going to put personal belongings, furniture, the exemption, and where that exemption comes from, either the Ohio statute or the federal statute. Okay? Your vehicle, there's an exemption. So you're going to list the vehicle on Schedule C, the exemption amount, and where that exemption comes from. If you look at illustration 8-A in Chapter 8 of your book, you can see that you lay out exactly what the exemption is, primary residence, the value of the exemption, okay, and where the exemption comes from, 11 U.S.C. section 522. Okay? So in this particular example, you see that the code section they're citing is USC, the United States Code. These are federal exemptions. You can use state exemptions too. But in this particular example, they've made the determination that the federal exemptions are higher, give you more than the state exemptions. So that's why you put them there. Okay? And that is continued on the next page all the way down. Okay? In order to use a state exemption, states have to opt out of the federal exemptions. Every state does it, so you don't have to worry about that. Okay? Your book talks about the limitations of exemptions. What you do is you completely list everything you can and then let the court tell you no. You want to make sure you are zealously representing your client. You put it in there unless a creditor comes and says, no, that's no good, or unless the court on its own says, I think it's a little bit lower. You don't worry about it. Okay? The next schedule is Schedule D. This is where you're going to list every creditor that has a secured claim, a secured debt. So those are going to overlap a little bit, right? Because you've got real property that's listed in Schedule A. Well, if you have a mortgage on that real property, it's also going to get listed on Schedule D. It's also going to go on Schedule C because you're going to put your exemption on there. Okay? It's okay if the same piece of real or personal property is repeated on these schedules. Okay? If you have a vehicle and it's listed on Schedule B and then it's listed on Schedule C with the exemptions, it's also going to go on Schedule D if you have a loan. So it's a secured claim. If I have carpeting that's listed on Schedule B, is something that I own. Carpeting's not a good example. Appliances that I own on Schedule B, right? I'm going to also take an exemption on Schedule C. And if I owe money on it, it's a secured debt, so it's going to go on Schedule D also. Every secured creditor. Now do you see why I said you have to understand what a security interest is and what a secured versus an unsecured creditor are, or you're not going to be able to fill out these forms, right? Okay, Schedules E and F, creditors holding unsecured priority and non-priority claims. These are debts you're not going to be able to get out of. Sorry. Domestic support obligations, pre-petition deposits of money for the lease or purchase of real property, tax claims, personal injury or wrongful death claims. Okay? You can't get out of them. Well, the personal injury claims and wrongful death claims, if they are intentional, you can't get out of them. Okay? So, all of these unsecured priority and non-priority claims, they're unsecured, but they still have priority. They're still going to jump to the front of the line. Okay? Schedule G, executory contracts and unexpired leases. This is kind of redundant because an executory contract is a contract that is yet to be performed. If you're in a lease, you're performing that agreement over the course of the life of the lease agreement. If I sign a lease today and it's for the next year, it's being performed over the next year. Okay? It's executory. It's not finished. It's incomplete. If I have a contract to provide so many widgets every month under a contract to a supplier, and I'm in month 4 and I file for bankruptcy, there's still an unperformed, unexecuted part of my contract, and I need to put that in there. Okay? For consumers, the typical one is your lease agreement. Otherwise, everything else is executed. Schedule H is co-debtors. Co-debtors. What if mom co-signed for your car? Yikes. Mom is on the hook for your payments, for your car payments. There's no other way around it. Co-debtors owe exactly the same debt as you do. They run parallel. It's almost like you guys both go into an agreement saying, okay, we're both going to owe this, but you're going to pay it. And you're not going to default, right? Said every parent who co-signed on a car. And if the child does default or files for bankruptcy, parent is still on the hook. And the court needs to know that. The court needs to know, hey, there's somebody paying this debt. So even though the debtor, the person who filed for bankruptcy, has listed this car payment, the car payment's getting paid because somebody else is paying it. So Schedule H is a list of all your co-debtors. It's letting the court know this creditor is taken care of. Okay? Schedule I is a schedule of your income. Why does the court want to know your income? Well, how much debt you owe and whether you're able to pay it is directly related to how much income you've got coming in, right? If I've lost my job and I'm only getting unemployment of $400 a month, but my credit cards are $10,000, $15,000 that I owe, there's no way I'm going to be able to pay that back. Or if I've recently been injured and I'm not going to be able to go back to work, same kind of analysis. Or maybe I lost my job and I now only have a part-time job. I can't take care of my obligations. Conversely, what if I have an income of $8,000 a month? Okay, why are you filing for bankruptcy? Well, maybe I got behind. Maybe I have just an extraordinary amount of debt from medical bills. So the court needs to look at what your income is to completely make a decision about whether it's okay to discharge your debts. Okay? Schedule J is your expenses. How much does it cost you to live? You know, maybe you make $8,000 a month, but maybe you have to have home nursing. Or maybe you have medical equipment that costs $5,000 a month. So it's important for the court to get the complete picture to know what your expenses are as well as your income. Okay? Then there is a summary of assets and liabilities. It's really just a chart where you're filling in the numbers from all the other, from all of the other schedules. It's just the bottom line. So there's one page that has everything in it. Okay? Then there's a declaration concerning debtor's schedule. And that's basically where you say, yep, that's all true. It's all true. A statement of financial affairs comes next. And this is actually a pretty complicated, not complicated, but it's very thorough. What are your bank accounts? Do you expect to get any money from an inheritance? Do you expect to get any money from a personal injury lawsuit? Does anybody owe you money? What's your tax refund for this year? Do you have a business? If you do have a business, tell us all about it. Okay? And so the financial affairs declaration, it's probably a good 8-9 pages long. And you have to truthfully answer all of those questions. Again, the court just wants to make sure they're not missing any source of income out there that you could use to pay the creditors. Remember, this is to protect the creditors. Okay? Next comes your statement of intention for either reaffirming a debt or redeeming a debt. What does that mean? If I want to keep my car, what I can do is I can tell the court, I'm going to reaffirm that debt. Don't include that when you get rid of all my other debts. I need a car to get to work. The car payment's $100 a month. If you get rid of all this other stuff, I can make that $100 a month payment. Just keep my car. Okay? A lot of people do that with cars. A lot of people will also reaffirm one credit card. Why is that? You have to reestablish your credit. So if you keep one credit card, one MasterCard, one Visa, or one Discover card, one major credit card that has the lowest balance on it, then you can continue to build credit even though you have a bankruptcy on your credit report. Okay? Statement about your social security numbers. You have to say, yes, this is my social security. There's a disclosure of compensation to an attorney. What? Why do you have to do that? Well, because the court wants to make sure that you're not hiding money by giving a big boatload of money to the attorney for fees that the attorney is basically holding as a constructive trust or holding for you, so that when the bankruptcy is over, you get money back. You get a refund, right? And so what the court wants to know is, wants to make sure that it's not a huge amount of money. And by the way, for a Chapter 7 bankruptcy, it's not a huge amount of money that the lawyer makes. Lawyers make a living on volume, not by charging a ton of money for Chapter 7 bankruptcies. Okay? You have to attach either your tax returns or your latest W-2 that has what you've earned over the last year. And there may be some other documents that the court will require. Kind of look at the local rules to make sure. Okay? You have to file all of this together. You can't just file Schedule A today, Schedule G tomorrow. It all gets put in one package. What happens if I leave a debtor off of my list? Well, I can always amend my petition. But the rules are, and again, this is why it's so important to file your petition in the place where you incur the debt, is there is a burden that we put on creditors to check public records about bankruptcies. So maybe I put a credit agency on as the debtor, but I mixed up the credit agency I thought was for debtor 1, it was for debtor 2, and so debtor 1 never gets put on the matrix and never knows what's going on. Creditor 1 has a duty to check public records every day to see if people that owe them money have filed for bankruptcy. Because creditors are required to make an appearance, file what's called a proof of claim, so that they can participate in the process. It's kind of a weird burden that we put on creditors to do that, but it is just kind of a recognition that there will be mistakes, and we're not going to upset the entire apple cart because there was an innocent mistake. Now, if it kind of looks like you were fudging, you got a problem. But why in the world would you leave a creditor off who is going to be discharged eventually anyway? So, even if there is an innocent mistake where you have the wrong address for a creditor, or you leave inadvertently one creditor off the list and it's not a secured creditor, the court's going to hold you responsible for checking that out. So if a bankruptcy petition goes through the process and all the debts are discharged under Chapter 7, and then a creditor comes forward and knocks on the door and says, wait a second, you still owe me money. Nope. The time frame within which the bankruptcy is filed, all of those debts up until the discharge date, the case ending in discharge, are gone. Period. Over with. Okay? So that's why we make sure that creditors keep tabs on what is owed, okay? And whether or not somebody has filed for bankruptcy. Okay? So, that's it for the schedules. I'd like you to go on the uscourts.gov bankruptcy website, pull up the schedules so you have a good idea of what they look like. Our next chapter, we're going to kind of finish up Chapter 7 bankruptcies, and then we're going to go into Chapter 13 bankruptcies, and then we're going to have our test. Okay? I won't be doing a big lecture that day. I'm simply going to tell you, here's your test, get it in. Okay? If you have any questions, as always, give me a call, email me, let me know you're not getting things, and we'll set up a time to go over everything. Okay? And again, if you have any questions, just call me. Thank you.